In the last section, you learned how insurance history, KLU, can affect insurability, underwriting, and closing timelines. Now we move into one of the most financially misunderstood documents in Arizona resale transactions, the HOA Condominium Planned Community Addendum. This addendum is not just HOA paperwork. It is a statutory disclosure tool that directly impacts closing costs, buyer cancellation rights, lien responsibility, and post-closing disputes. It integrates with ARS, Paragraph 33, 1260, condominiums, and ARS, Paragraph 33, 1806, planned communities, and it must be handled with precision. Seller's notice of HOA information required at time of listing. Page 1 requires the seller to complete association information at the time of listing. This is critical. The instruction specifically requires the form to be uploaded to MLS if available, or delivered to prospective buyers upon request prior to submission of a contract. Arizona Practice Standard, HOA Fee. Transparency is not delayed until escrow. It begins at listing. Gilbert. Example: a property in Power Ranch has both a sub-association and a master association. If only one is disclosed at listing, buyers may underestimate monthly obligations. That creates renegotiation risk once full resale documents arrive. This section forces early financial clarity. Fees payable upon close of escrow. Breaking down the real costs. The addendum separates fees into categories: transfer fees, capital improvement fees, prepaid association fees, disclosure fees, other fees. Each category has different statutory treatment and contractual allocation. Transfer fees, charged by the association for processing title change, capital improvement. Fees, sometimes labeled reserve contribution, working capital, asset preservation, or enhancement fees. These can be substantial in newer master-planned communities. Prepaid dues, often prorated or prepaid to align billing cycles. Disclosure fees, capped under Arizona law at an aggregate of $400 per association, with limited update and rush fees allowed. This statutory cap is critical knowledge for brokers. Queen Creek example: buyer is surprised by a $2,000 capital contribution fee at closing. If disclosed early in the addendum, expectations are set. If not disclosed and discovered later, the buyer may attempt renegotiation. Seller certification and broker non-verification clause. The seller certifies that information is true and complete to the best of their actual knowledge. Brokers do not verify the HOA fee amounts. This clause is a risk management boundary. It protects brokers from fee misstatement liability while reinforcing seller responsibility. Additional obligations. Based on association size. 50 units rule. Arizona law distinguishes between associations with fewer than 50 units and those with 50 or more. If fewer than 50 units, seller must provide required resale disclosure information within 10 days after contract acceptance. If 50 or more units, seller must provide notice of pending sale within 5 days, and the association must deliver required information to the buyer within 10 days after receiving notice. This timing structure directly affects buyer review rights. Buyer 5-day review period. A statutory cancellation window buyer is allowed 5 days after receipt of the HOA information to provide written notice of any items disapproved. This is a statutory protection period. It operates independently from general inspection rights. Chandler example. Buyer receives HOA documents revealing rental restrictions stricter than anticipated. Buyer delivers written disapproval within the 5-day window and cancels. This is lawful and protected. If deadlines are missed, cancellation rights may be waived. Timing matters. Buyer allocation of fees. Negotiation within the addendum. The addendum allows parties to designate who pays. Transfer fees, capital improvement fees, undisclosed fees, prepaid fees. By default, buyer pays prepaid association fees. Seller pays disclosure fees as required by law. Seller must pay any current HOA assessment lien existing at close. Assessments that become a lien after closing are buyer's responsibility. Contract writing integration. Fee allocation is negotiable unless dictated by statute. Clear allocation prevents escrow disputes. Assessment lines, pre-closing versus post-closing responsibility. Any HOA assessment that is a lien at close must be paid in full by seller. This is critical because unpaid assessments can impair title transfer. Title companies will require payoff. MESA. Example: seller has an unpaid special assessment that has already become a lien. That amount must be cleared at closing. A future assessment approved, but not yet a lien, may transfer responsibility to buyer. Understanding lien timing protects both sides. Buyer verification and hold. Harmless clause. Buyer may contact the association or management company for verbal verification of fees. Buyer acknowledges that precise amounts may not be known until official resale documents are issued. Buyer agrees to hold seller and broker harmless if amounts prove incorrect or incomplete. This clause reinforces that the addendum is an estimate tool, not a final settlement statement. Contract integration, HOA deadlines and inspection period. HOA document delivery deadlines and 5-day review windows must be coordinated with inspection periods. If HOA documents arrive late, review windows may overlap or extend beyond inspection timelines. Professional standard. Track HOA delivery dates carefully and document receipt. Failure to manage deadlines can expose brokers to supervision concerns under AAC R4 28-1103. Course discussions with answers. Discussion question: why must the HOA addendum be completed at the time of listing rather than waiting for escrow? Answer: because fee transparency is required early, and uploading or delivering the information before contract submission reduces surprise costs and renegotiation risk. Discussion. Question: what happens if the buyer delivers written disapproval within 5 days after receiving HOA resale information? Answer: the buyer may cancel the transaction pursuant to statutory rights within the review window. Discussion. Question: why is the distinction between assessment liens existing at closing versus after closing important? Answer: because liens existing at closing must be paid by the seller to clear title, while assessments becoming liens after closing typically become the buyer's responsibility.